Good morning, everybody. Hello. Welcome to today's webinar. My name is Amanda Chadwick, and I'm from Peninsula Business Services, and I'm a senior speaker at Peninsula Business Services. Today's webinar is on policies, procedures, and tips every business should know and have in place, really, to protect themselves against the pitfalls of employment law, a bit of health and safety as well, but also ultimately to avoid a tribunal. I've worked at Peninsula now for 12 years. I'm a speaker at Peninsula. I speak for nearly every federation, association, business group in the UK. It's 19th of August today, and we're going to start this webinar today just on a few facts, a few recent changes in tribunal, just to keep you up to date, but also recent statistics. And then what we're going to do in this webinar today is that we're then going to talk about the top 10 pitfalls of where an employer goes wrong, or a manager, or an HR, and then we're going to go on to the right policies and procedures that you should have in place. And hopefully by the end of this webinar, which should end about 45 minutes time, is you should be really refreshed and understand a little bit about employment law and feel very comfortable. So, okay. Right, just some recent things to talk about. A tribunal update. The HMCTS has published a report showing tribunal statistics for the period the 1st of January to 31st of March 2013 are showing a significant jump in the number of claims made in comparison to the same period in 2012. In fact, 36 more claims were made in early 2013 than were made in early 2012, with a total number of 57,737. The number of claims, and I always mention this in my webinars, you know what, it's always a hot topic in tribunal, but the number of claims made under the Working Time Directive, and that is holiday pay, that's maximum working hours, and breaks, etc., has doubled in comparison to last year, making up just over a third of all claims. And remember, top tip here, the Working Time Directive, that's holiday breaks, working hours, it falls under health and safety. So remember that post you've got up at work, it mentions the Working Time Directive on there. So keep up to date with that. Second in the list behind the working time claims were unlawful deductions, so failure to make correct payments, etc. And that was making up 16%, and that was followed by unfair dismissal claims. So remember, if you want to take money out of people's wages because you've overpaid them, either holiday pays or you've overpaid them, or you want to deduct money from their wages, you need to have a written agreement. You need to have that written into your handbook under your standards and expectations. You cannot deduct money from people's salary without a written agreement. So make sure you got that in your handbook or in some form of the contract. Okay, our recent update on cases that we've recently handled. Just to let you know, in July, a cook who worked for a countrywide care home operator was made redundant. She brought a significant claim in the region of 30k before the employment tribunal on the basis that it was a sham redundancy. And the reason she had been dismissed was because she was a whistleblower. She had blown the whistle to the local authority regarding the operation of the care home. There was significant press interest in the case. The cook had indeed blown the whistle, but we at Peninsula were able to persuade the employment tribunal that this was not the reason for her dismissal, and the case was dismissed. So, a couple of other updates. Sexual discrimination case, constructive dismissal case, and breach of contract case was heard at Cardiff Tribunal on again another case in July in Liverpool on the 8th of July, and it was a case for unfair dismissal and a holiday pay claim. Again, similar, 33,000, very large amount there, successfully defended, no award. So I thought I'd give you a real positive start to this webinar today, on recent cases we'd handled. So, hot topics on our advice line at the moment: zero compromise agreements, recent change in auto-enrollment. People are taking it seriously now. Should have been taking it seriously months ago. If you need any help on that, we're going to be doing a pensions, or I will be doing a pensions update and a webinar very shortly, so contact me about that. How to conduct a disciplinary. Even the most experienced HR people, managers, etc., always need a pat on the back to know how to conduct a disciplinary and make sure they're going down the right route. Everybody remembers 2003. They remember that big change with the procedures, and they don't want to get stuck again. So we always like a pat on our back just to make sure we're going down the right route. Conduct and capability. Always a question we get on our advice line. What do we do about this conduct? What do we do about lateness? What do we do about somebody smoking? What do we do about capability when somebody doesn't see you up to the job anymore? And reducing suspension costs in the health sector, major issue at the moment because of all the governing bodies around the care sector and people saying that we have to suspend them on full pay because all the governing bodies are asking us to do that, but it's cost us a blooming fortune. How can we reduce those costs? And have I missed any major changes? Believe it or not, we get that because you get swept away with your business, don't you? You're working on your business, you're working extremely hard, you are actively part of the business. Even if you're the owner, you're a manager or HR, you've got other jobs to do. But you know what? We forget about any changes in employment law. So we forget about pensions. We forget about the tribunal reforms. We forget about the updates April and October. And we have to keep up to date. So the calls that we get, is we get a phone call or advice line and we just get somebody saying, have I missed any major changes in the last 12 months? Please let me know. So, okay, top 10 common pitfalls then for you, the person listening to me today, that people commonly make. The first one is not issuing a statement of main terms of employment. Now, some people may be very experienced with this. Some people will be listening to me today. I believe I've got about 500 people listening today. So I know that a lot of people out there will think, what is a statement of main terms? So I'm going to clear that one up for you. Me, I come for an interview with you. I'm sat in front of you now. And you've discussed the job with me, you've asked me questions about myself, you're selling your company to me, I'm selling myself to you, okay? And we're talking about the company, and you say to me, is there anything you would like to ask me about the job? I'm going to ask you, as a human being, what is the title of the job? Where am I working? How much am I getting paid? What are the holidays like, etc.? Because that's how I run my family life. So I'm asking you about the job. Job title, location, hours and pay. That is somebody's statement of main terms. That is my personal contractual terms with you. And many employers who find themselves with a tribunal claim or an unfair dismissal, that's a new word, isn't it? Unfair dismissal claim, find themselves with the added complication of failing to comply with Section 1 of the Employment Rights Act 1996. And that is issuing a written statement of main terms of employment. This can be a costly error, as a tribunal can fine the employer the equivalent of 4 weeks' wages on top of the award, and all because they didn't issue the employee with the correct documentation. The average award for failing to issue a statement of main terms is £1,428. That's a lot of money, that. So really, when you take somebody on, you make sure you issue that piece of paper, where they're working, how much they're getting paid, etc. Because actually, for me, that is my personal contractual terms anyway, and I want to see it on a piece of paper. I would advise my clients to issue that when they offer them the job. So send the job offer out, send the statement of main terms, they sign a copy, they sign 2 copies, they keep 1, they send 1 back to you. And then what we do on day 1, we have the induction, we issue the employee handbook, which contains the conditions of employment, which we're going to talk about shortly, and the policies and procedures. Second common pitfall is not issuing standards and expectations. How the hell anybody could run a business without standards and expectations in place is beyond me. You know, handbook with the conditions, and we like rules, don't we? But the handbook is, you know, you want the job with me, these are my rules, and a lot of this, 90% of this, is not law. 90% are your rules, and you can have whatever you want in that handbook as long as it's reasonable. And we're going to talk about some fantastic policies in there shortly. We're going to talk about social networking, blooming hot topic that one is. We're going to talk about suitability clause. We're going to talk about policies and procedures that help you save money within your business. So wait for me, I am going to get there. So standards and expectations, the handbook with the conditions. 3, making sure you have the right disciplinary grievance procedures in place. And let me point out to you, we've all got a friend that's a solicitor, we've all got a friend that works in HR, we've always got somebody who's been in, you know, a managerial position for years, and even with our own handbooks written, we still seek advice from one of our friends. They don't know what you've got written down. Please, top tip here, follow what you have got written down, because you could be breaching your own contracts. So, making sure you have disciplinary and grievance procedures in place and follow them, and make sure you get it right. Dismissal, the reasons and emotion. Make sure, you know, that you investigate properly for dismissals. Investigate before you make a dismissal. Investigate when you're holding any disciplinary or grievance or appeal. Even if, you know, somebody's pleading, you think, I can't be bothered, they're guilty. You have got to do the investigation and make sure that you don't show emotion. I always talk about that letter that somebody typed up before they even held the investigation. And guess what? They sent out the letter for the dismissal out instead of the invite to an investigation. Emotion, you know what? Don't let that overcome your decision. But also at the same time, lots of people can have a tribunal because they've let emotion get involved. I might work for you, you might not like me, and I one day in temper say, shove your job, I'm not working for you anymore. And actually you might be really delighted. But the fact is, what you should do is take a step back. You should give me time for reflection and write to me to say that you're giving me time for reflection and that you're inviting me back in for a meeting to discuss any issues that we might have. And you know what? That's your paper trail. That is your defence. And all I'm looking for to defend my clients is a paper trail and defence. And then we've got discrimination. You yourself might not discriminate, but your staff might. So we look for an equal opportunity harassment policy. We're going to talk about that later on. And we're going to talk about discrimination. And you've got to have that policy in place. And for everybody sat there today listening to me, the most up-to-date equal opportunity and harassment policy should include this: race, religion, religious belief, no belief, environmental belief, political opinion, affiliation, marital status, disability, gender, gender reassignment, age, and sexual orientation. I've done that off the top of my head. I hope I haven't missed any out, but that's your most up-to-date policy and what you're showing as an employer, because you are busy doing your own stuff. If you're a manager and you're HR, you're busy doing your own stuff, you've got that in your handbook. It's giving you peace of mind because you're saying to your staff, you take discrimination seriously. And if anybody feels that they're being discriminated against, you know what? They come to you and allow you to sort it out. So speak to your staff and act early enough. Do you know what? I do a lot of mediation work as well. And I can tell you now, I sit there sometimes and I don't just think it, I do say it. I sit there and I just say, this could have been sorted out right at the very beginning, you know. We don't have to be here now. We're entering into a compromise agreement now known as a settlement agreement, and we're paying somebody off because mistakes have been made. This could have been sorted out at the very, very beginning by speaking to your staff. If somebody says, I've got a complaint, I've got a problem, listen, ears prick up, sort it out at the very beginning. But also as well, by trying to sort it out at the very beginning and proving you're a good employer, a manager or HR, actually it can reduce the pay at the end. And it actually can prevent a tribunal in the first place. So speak to your staff and act blooming early. So now we've got training. That's keeping up to date with employment law. That's also training your staff. You have vicarious liability. You are responsible for the actions of your staff. So remember to keep them trained, managers trained. And that paper trail, it's so easy not to write things down. It's so easy not to produce a letter and print it off. That paper trail has got to be in place because those are our defence documents. They are your defence documents. So if somebody's saying to you something as simple as, I would like to work part-time, you reply, that's great. But what I request that you do is you apply in writing. And then you keep a copy of that letter, you consider that request, and you let them know you're considering that request in the response of a letter. So, again, consistency. Oh my goodness me, the amount of people that are not consistent in their decisions. I work for you. And actually, we're going to talk about my photograph later on. And we're going to talk about me as a person, but what you don't know, actually, is that I do have 4 children and I have 2 grandchildren. Maybe you do know by looking at me. I haven't had Botox yet, and that's maybe something I might consider in the future. But I have got 4 children and I've got 2 grandchildren, and I work for you. And you know what? I've worked for you for a long time, and I'm a really hard worker, and I'm never off sick. I ring in today and I say, I'm really sorry, I can't come into work today because my daughter, my eldest daughter's got into labour, you know, and she's producing my 3rd grandchild. You think Amanda's a really blooming good hard worker. Do you know what I'm going to do? Is I'm going to pay her for that day. You pay me, okay? So that's scenario 1. Scenario 2, another woman works for you and she's in her 40s, and she's got a child who's sick all night. She's been there a number of years and she's a good hard worker. She rings in the same scenario and you pay her. Next scenario, you've got a 16-year-old woman working for you. She's only been there a week. She's got a baby who's got earache and she's off for the night. She doesn't come in. It's her second day of employment within that first week. You don't pay her. That's not consistent, is it? What we've got is we may have a case of age discrimination because we paid the woman that's been there for a number of years, who's got a baby, but we haven't paid the 16-year-old. That 16-year-old hasn't got the length of service the other person has. Is that age discrimination? And we're not consistent. So we've got to be consistent. And by the way, that's called dependence. That's called time off for dependence. And actually the law says that it's unpaid. If you want to pay it, that's great. But my top tip for you is be consistent. If you're paying, you pay everybody. If you're not paying, you don't pay anybody. And manage it under absenteeism. And the final say here is the top 10 common pitfalls. Number 10 is redundancy and not getting that right. So, and by the way, redundancy is a last resort. Before you go through redundancy, I like our clients, before they even make it as a redundancy, or when they're even just thinking about it, I want them to ring us because we can come up with an alternative, hopefully anyway. And one of those alternatives might be shortage of work, it might be breaking down the hours, and it might actually be a layoff. But we can only do that with a written agreement in their handbook, and it's absolutely business respite. You don't get anybody in the government shouting out, do you, going, hang about, why don't you use shortage of work? Why don't you use the layoff procedure? But you know what? It's business respite, and it's absolutely brilliant. Let me give you an example of how that could be used before we move on. Have you got shortage of work or layoff procedure in your handbook? Think about it now. Have you? And let me give you a scenario. Pretend I own a sandwich shop. I own a sandwich shop, one of those ones on the high street, not one of the pret-a-manger ones, but that could be the one. But, we're talking about, your little butty shop on the corner of a street near you. I'm really busy, and in fact, I'm a cash-in, cash-out business. So when people come in, I make their sandwiches with my 3 staff and I pay them. Those staff have been out here for years, and literally I get my money in the till, I pay the wages and pay my utilities and my lease hire, etc. One day I come into work and guess what? Outside my front door there's been a flood. The drains have burst and the road is absolutely blocked off. This is going to be going on, I don't know, they say at least a week. That's 7 days of no sandwiches sold. 7 days of a cash-in, cash-out business with 3 people that want their wages. This is where a layoff procedure is in place, and it's a layoff procedure that we can utilise. By the way, the only people buying the sandwiches are the 2 workmen digging up the road. Okay? They're not going to help me, are they? They're not paying my bills. 2 butties a day really isn't going to pay my bills, and it's not going to pay the wages of the 3 staff. I don't want to make them redundant because I know that there will be light at the end of the tunnel and I will be back in business very shortly. But there is a problem here. Now, what we might do, there might be options of where I might say to people, take your holidays emergency, and I have the right to do that, and there are terms and conditions surrounding that, but I have the right to say to somebody, take some holidays. I could say to them, do you want to take some holidays and consider that? Or I could actually say, we're going to lay you off. And that might be that I lay them off on statutory guarantee pay, and I can lay them off. And it might be something like a flood, it might be a fire, it might be a fatality, it might be anything like a riot on the high street, it could be snow. There might be something out of my control that allows me to lay my staff off on statutory guarantee pay, which isn't as much as their wages, and it allows me business respite. And when I'm back up and running, I bring them back in, and it's not redundancy. Do you have a layoff procedure in place? Do you have a shortage of work procedure in place? What you've also got to remember today when I'm talking to you is I'm giving you an overview. I'm giving you an overview of a policy or a procedure, but I recommend to every business that I deal with, and I have dealt with millions of businesses now, that they get a shortage of work and a layoff procedure in place as form within their handbook straight away. So the basics, I want you to have policies and procedures in place, and those policies and procedures we're going to talk about very shortly. I want standards and expectations, what I'm expecting of an employee when I take them on. Listen, if you're late, I've got a lateness policy. And what it says, this is just an example of my standards and expectations in the handbook. The lateness policy is tailor-made to the business that I'm talking to. So if I'm dealing, for example, with a factory, I'm going to have a lateness policy because we're dependent on people on shifts, and we're dependent on the person coming off a shift for the other person to come in and take over that role. And what I'm going to do is I'm going to have a lateness policy that says if you're more than 5 minutes late, I deduct 15 minutes pay from you. If you're more than 15 minutes late, I deduct half an hour's pay from you. If you're more than an hour late and you haven't even bothered to tell me, do you know what? I've obviously got somebody else to cover your job, and when you come in, I'm going to send you home without pay, and you won't do that again. So we might not be as harsh in some policies in some businesses as we would in another. I know when I deal with doctor's surgeries, for example, if they have somebody who's late, they just put their glasses down and they look at them, and the person literally won't come in late again because they felt the feeling within the office. And maybe a lateness policy wouldn't be needed in an environment like that. But when we're dealing with shifts, we're dealing with the care sector, for example, we would have a full lateness policy. But also what we would do when we're talking about shift workers and overtime in any business, what we would do is we'd tie the lateness, sickness and overtime policies together. And what we would say is that if you haven't met your core hours within 1 month, you don't qualify for overtime. And what that deters, it deters somebody ringing in sick on, say, for example, a Friday, but then working overtime on a Sunday and getting double pay. So they've only got a day off, but also getting double pay as well. So I think that's a really good clause to have in your handbook. And remember what I'm saying, you can have what you want as long as it's reasonable. But remember, every business is different. I don't magically just copy every handbook and hand it out to different businesses. They've got to be tailor-made. You've got to, and you know your business better than anybody. You're listening to me. It's all right me giving you an overview, but you certainly know your business better than I do. And you know the personality of your business as well. So you know what would stick with your business and how harsh you could be, or how, you know, how these policies work and how effective they would be. You know, when you're dealing with hundreds of staff, then the latest policy has got to be short and sharp. But when you're dealing with an office where there's 5 people that have worked together for years, literally it's just a one-liner, and it's the atmosphere that makes people not be late. So the standards and expectations, and don't, for goodness sake, lose the personality of your company when you put policies and procedures in place. You know, that's how good you are as a business, the personality of it. But you know, by law, we've got to have a statement of main terms, and you can't run a business without a handbook. Really, it's got to, that's your conditions of employment, that's your standards and expectations. I've spoken about the paper trail in defence, and it's a paper that says, I've spoken to you on this date, and believe you me, your staff are keeping a diary on you. You must keep a paper trail on them. And then we talk about the induction and the formal documentation. The amount of businesses I deal with when I first take them on, and I deal with them and I speak to them, and they've never done an induction before, or they never have used application forms or have formal documentation, and they're quite alarmed that I'm suggesting having an induction or using a formal documentation. And they're thinking, my gosh, I'm a pub, Amanda, for goodness sake, you're talking rubbish. Why would I use an application form? Why would I have an induction? And I say to them, look, I'm not asking you to rock the world here. I'm asking you to have a bunch of application forms under the counter in the pub. And when somebody walks in off the high street, and you'll get this like at hairdressers, bakers, you'll get this on any high street store, especially when you get your school leavers. They'll knock on the door and say, have you got any jobs going? And isn't it handy to have a bunch of application forms there and then, and you can hand one to them? And I'm not asking you to, you know, excuse me, I'm not asking you to, you know, fill it in for them. You know, it's literally a piece of paper saying, please could you fill that in and give it me back. And what you're doing is, it's a legal document if it says it. And we're going to talk about that in depth very shortly. And then the induction, what you're allowing there with the induction form is when you're offering somebody a job and you've brought them in and you're having the induction, you're getting them to fill their name and address in. It's a checklist for you, the employer, and you're checking the P45, the driving license. But what you're doing is you're getting a written agreement for them to say that I've read and understood, and understand is a winning word for me legally. I've read and understood the handbook that contains the policies and procedures. I've read it and understood it. Imagine how powerful that statement is later on for us in a tribunal. And then I've read and understood the training for health and safety. I've read and understood the health and safety policy. And again, we can't backtrack then, can we? So we've got that in place, a formal induction, and that goes on the employee file. And then we've got the training, the education of the management. You've got vicarious liability, and just an up-to-date understanding of employment law. And then what we've got the state and the main terms, which you spoke about earlier, and the penalties. We've got the employee handbook, which is going to contain those policies and procedures, which I'm going to talk about in a moment. The application form. Right, this is preventative, this. The application form is preventative, and I'm going to talk about really old-fashioned tribunals here that I've spoken about loads and loads of times, but help you understand why it's important to use application forms, okay? A company, a telephone answering company, has a man apply for a job. He sends off a CV. He sends it by recorded delivery. He receives no reply. He doesn't get an interview. A couple of days later, he sends off another CV because he sees the job still advertised and can't understand it. This time he chooses a female name. He sends it off by recorded delivery, and they receive the CV in the lady's name. She gets an interview, and he didn't, but he sent both the CVs. What we now have is a case of sexual discrimination. How can that happen? It's on the CV. A CV is not a legal document. How are we going to prevent that happening to us, Amanda? By using an application form. An application form that says that it is a legal document, and if you lie or give misleading information on this application form, it's fraud and deception. A simple document is preventative in having a tribunal. And then we use interview rating cards. You know, when somebody comes for an interview, why didn't they get the job? Actually, because you lost out on personality. So what we have is we have a point system on the interview rating card, and it's really hard, you see, when you're interviewing lots and lots of people to remember who you've interviewed. I know my brother recently was made redundant from a job. He works with in the housing section of our community, and he works with the difficult side of the housing, so people that have come out of prison and also other areas of housing. He was made redundant in his job. He's now, I'm glad to say he's actually now got another job, so that's good news, isn't it, for everybody out there? But anyway, he was made redundant from his job. He's now got a new job, but in the process of applying for this job, there were 749 applicants for that particular role. Mistakes can happen if we do not use formal documentation. How the hell you can remember who you've interviewed on a day-to-day basis if you're sifting through that many people, I don't know. So let's formalise this. Let's not make mistakes that are costly to our business. Let's use application forms. Let's use interview rating cards, okay, to formalise that process. So what do we use next? We've got holiday request forms, so people request a holiday, sickness, injury records. We've got exit interview documentation. And I ask you the question, even the most experienced people listening to me today, do you do exit interviews? And you know, we all make mistakes in business life, and sometimes we get carried away with our business and we forget to look inside our business and learn from our own staff. And so it's always a really good idea to do an exit interview, I feel, because we learn a lot about our company. So when our company is, you know, somebody's leaving our company, we might not want them to leave, but we want to find out why they're leaving. But also, imagine if I work for you and I'm leaving your company, and I haven't mentioned why I'm leaving until we sit with the exit interview. And then you say to me, Amanda, why are you leaving? And I say, because I've got a new job with more money in a car. That sounds quite honest, doesn't it? So you say, oh, well, good luck then, Amanda. Good luck for the future. And I leave. But a few weeks later, you receive tribunal papers from me. And the real reason I'm saying that I left your company is because I was sexually harassed and bullied throughout my career with you. And the thing was, it wasn't you that bullied me, and it wasn't you that sexually harassed me, it was somebody else. So at the exit interview stage, by the way, I did have the opportunity to say that to you and chose not to. But also, on the exit interview that says this is a legal document, I lied on it and said the reason I was leaving was because I had the new job with more money in a car. But also, in your handbook, you've got a harassment policy, you've got a sexual harassment and bullying policy, and Amanda's never brought it to your knowledge before. And after further investigation, actually, you find out Amanda wasn't successful in her new role, and you feel that this is money motivated. See how the evidence is all on your side. So that is why it's so important to have policies, procedures in place, and to use the right documents. So exit interviews not only help you learn about your company, but can be preventative in a tribunal situation as well. And then staff appraisals and KPI systems. I've done separate webinars on these. I really have, and I've actually sat there and I've spoken in depth about KPI systems and staff appraisal systems and how they're absolutely brilliant at managing your staff, but they're also great to use as evidence when we're sort of speaking to somebody about their performance. I cannot believe people will operate a company, even if they do them annually, without staff appraisals and KPI systems in place. So, what are the policies that I recommend? Well, sickness, injury, payment and conditions. There's a policy that screams out to me. Disciplinary rules and procedures. You've got to have them in place by law. So make sure when you do have them in place that you follow your own and not somebody else's. Capability policies and procedures. And you might be sat there thinking, what is capability? Well, actually, I think I'll read out at this stage what a capability policy is. Have you ever had somebody that works for you and they just do what they're expected? They come in at 9 o'clock and they clock off dead on the dot at 5. They never go over the odds. They never do cartwheels at work. They're going to be there forever. They're never going to do more than you ask them to. And basically, they don't add to your business. They just tick away. Now, this is where KPIs and appraisals come in, actually, because you can identify this earlier on. But capability might also be for that person, but it also might be for somebody that actually their health is deteriorating. It might be age. It might be that they've had an accident. So what I'm going to do is I'm going to read out a capability policy to you. And I just want you to have a listen to this, because this is really helpful for somebody. Because sometimes when it comes to sickness or health, and it might be a long-term sickness that we don't want to deal with, and we don't want to give somebody an answer to say we need to look at your sickness, because it could be something like cancer, which we all, is uncomfortable to deal with. But what we have is a capability procedure in place that's self-explanatory, and it helps us as an individual that's dealing with this issue. So what we have, first of all, is we have it under capability procedures, and we have it with an introduction. And the introduction should say something like, we recognise that during your appointment with us, your capability to carry out your duties may deteriorate. It can be for a number of reasons, and the most common ones being that either the job changes, and we've seen that could be like computer systems coming in, a new piece of a machinery, and it might be that either the job changes over a period of time and you fail to keep pace with the changes, or you change. And the most common reason because of this is health, and you can no longer cope with the work. We go to the next section, which says job changes and general capability issues. If the nature of your job changes, or we have general concerns about your ability to perform your job, we will try to ensure that you understand the level of performance expected of you and that you receive adequate training and supervision. Concerns regarding your capability will normally first be discussed in an informal manner, and you will be given time to improve. And I've got a great example there. A business over in Oldham, 3 ladies work there, been there for absolutely, I'm not joking, not donkey's years, literally 30 odd years, and they've been there for years. They introduce a new computer system, and all 3 women go off sick with stress. This, to me, screams out a capability issue. They're frightened that they might not be able to keep up to date with the training and the computer. After negotiations, conversations with them, informally, we spoke about the training that we needed to go through. And you know what? They're still there within the company, and they can use the computer system because they've had adequate training and supervision and support, and it's not gone on to the next level. So, if your standard of performance is still not adequate, though, you will be warned in writing that a failure to improve and to maintain the performance required could lead to your dismissal. We will also consider the possibility of a transfer to more suitable work if possible. Look, we're reasonable, aren't we, as employers? We'll look at alternatives for people. We'll work with them to try and get them to where we want them to be, especially if somebody's been there for a long time. So if there is still no improvement, though, after a reasonable time, and we cannot transfer you to more suitable work, or if your level of performance has a serious or substantial effect on our organisational reputation, you will be issued with a final warning that you will be dismissed unless the required standard of performance is achieved and maintained. If such improvement is not forthcoming after a reasonable period of time, you will be dismissed with the appropriate notice. So it gives you the impression we do work with you. We do work with you as far as possible. But at the end of the day, we are running a business. That's ultimately what you're doing. But personal circumstances and health issues are very common, and they may arise which do not prevent you from attending for work, but which prevent you from carrying out your duties. So, for example, the most common one actually is lack of dexterity, and I can tell you where I use that one. Lack of dexterity is where somebody comes into work, but they're not doing the job like they should be. Their mind, as my mother would say, they're away with the fairies. So basically their mind's on other things, and it might be because of relationship issues, it may be because of debt, and these are common things, and I'm a real true believer in an employee assistance program in those situations where somebody has an unbiased a telephone number they can ring for support, but where they can get debt help or relationship issues. But that's usually what we see. Somebody can't have the time off because they need the money, but they're no use in an ornament when they're in work because they're not doing the work they should be doing, and they're making mistakes. We need to speak to them about it. So which prevent you from carrying out your duties. Example, a lack of dexterity or general ill health. If such a situation arises, we will normally need to have details of your medical diagnosis and prognosis, that we have the benefit of expert advice. And under normal circumstances, just to let you know, you can actually only get these by asking their doctor, but you'll need their permission for that. And when you've obtained as much information as possible regarding their condition, and after consultation with the employee, a decision will be made with you about their future employment with them, in their current role, or where circumstances permit in a more suitable role. Sometimes, though, in personal circumstances, might prevent them from attending work, at all, so they're not in work, and it might be for short bursts, or it might be for prolonged periods. And if there's something frustrating I always get off people, it's always they're talking about sickness. They always say, what do I do about sickness? And there's no proper answer to it, I'll be honest with you. I want to see a sickness policy. I want to see sickness procedures in place. I want to see a proper report on how people ring in, and that people don't text in. But I want to see a capability policies and procedures in place, because they help you. And again, it's access to medical records with the employee's permission. And then when you've got as much information as possible, then you can make a decision, can't you? So again, that's the capability policies and procedures, and we tie them in with disciplinary, and we tie them in with sickness as well. And then what are the policies? We're looking at equal opportunity, bullying and harassment policy. And what you're doing there is you're giving somebody the opportunity with that policy in place. It's there. And if ever they feel they're being bullied and harassed, or they feel that they haven't, they're being sexually harassed, bullied or whatever, you've got that policy in place and equal opportunities to prove to them that you take it seriously. And there's an informal route to begin with. And it also self-explanatory how, if they're being bullied, harassed, how they can write a letter to the harasser if they want to at first. And that's what I like to see in a handbook. Now, while you're listening to me, you might be thinking, oh, I bet the handbook's about 34 pages long, isn't it, Amanda? But it's not. It's actually, our average handbook is about 24 pages long, and it contains everything I'm talking about. And then what about a search policy? Have you ever heard of one of those? Really, have you ever heard of a search policy? Have you ever used one? Do you think it would be offensive? Well, for me, it's about control. It's about managing your business. And a search policy isn't just about stealing, although it's very good to have there. It's about the social networking side. It's about people using the mobile phone when they shouldn't be, and being able to search them to prove that they are. And remember, with a search policy, you're not touching somebody. You're not taking their clothes off or anything, put them back on, but it's not that. A search policy is actually me saying to you, I have the right to search you wherever you are working for me. So that means if you've got a lorry that belongs to me and you're driving my goods around the country, and I find that lorry's taking a detour somewhere else, I have the right to search that lorry wherever it is. I've got a tracking device in there, and I know where that lorry is at all times. By the way, if you have got a tracking device in there, use your iPhones or any social networking device that has a tracking device. You need to put it in the handbook, by the way, because otherwise you're breaching human rights and data protection. So make sure you get that in there as well. But the search policy, I have the right to search you wherever you are working for me. So if you've got carers, cleaners, or a salesperson goes out and works off-site, you have the right to search them wherever they are working for you. You have the right to search your vehicle. You have the right to search your lockers. You have the right to search them, but you're not saying to them, I'm touching you. What you're actually saying is, could you take your jacket off, please? Could you empty your handbag? Could you open the car boot of your car? So you're not touching them, because that's assault. And remember, again, I'm giving you an overview. I'm just giving you an overview of a policy. So I have the right to search you, and it's for stealing, It's for drug abuse, it's for alcohol abuse, it's for using a mobile phone when you shouldn't be, it's for smoking when you shouldn't be, it's for all those reasons. But the thing is, you see, if I'm guilty, I'm not going to say, oh, here's your bottle of vodka, I was only joking, or, oh, I didn't realise my mobile phone was there. I'm going to refuse a search, and that's when you tie it to gross misconduct. Gross misconduct, you tie the search policy there. Refusal of you to agree to be in search will constitute a breach in your contract. And check out the reasons for dismissal. One of them is refusal of a search. So amazing policy. Think about it while I'm talking to you. Fantastic. Social networking policy. I've done a webinar before, and I'm sure I'll be doing one very shortly again on social networking and the implications. But we on our advice line, we're getting lots and lots of questions about social networking and Facebook and people making comments about their staff. It is not unreasonable for you as a written request in your handbook to say to somebody, you can't have my company name as your employer. You can say what industry you work in, but you can't say the company. Because if somebody's on Facebook talking about, what they did last night in the bedroom, or in a nightclub, or what drugs they're taking, or what they've been up to, it has implications on you, doesn't it, in some cases, especially if you're dealing with children. You're a teacher, or, they work for Page 3 in their spare time. What you don't want is your company name may be associated with that. So what we would suggest is that in your handbook you have a social networking policy, and it's not just a Facebook policy, it's a social networking and social media policy, and it's very, very explicit. It says, and it needs to be kept up to date, this one, all the time, because social network, we've got Instagram now, haven't we? We've got those short videos that come through, and my brother was telling me about it last night. All sorts of policies, all sorts of things that are happening now. We've got Twitter, they might be saying things about your company. So let's rein this in. We've got LinkedIn. Let's be specific about what you want and say you can't talk about my company, you can't talk about my clients, my friends, you can't have them as friends on Facebook. I haven't got time to give you examples today, and maybe I'll do that on another webinar when we talk about social networking another time. But think about that policy. We're writing it. And anybody listening to me today that is one of our clients, and you sat there thinking, oh, I wouldn't mind that policy, because when we take you on, we put in what you want in place, whatever you would like. And social networking might not have been the top of your list then. And if it is now, don't sit there struggling to write it. That's what you're paying us for. We will write that policy for you. So let us know if you want that writing. And then the mobile phone policy. It is not unreasonable to say to somebody, you can't use your mobile phone in work. End of. Does anybody on the end of this webinar remember 1984? Because I do. And that's why I've still got that curly hair, isn't it? It was fashionable then, it's back in fashion now, but I've been out of date for many years. But the mobile phone side of it, in 1984, the only people with those mobile phones were the brick ones, and you were really mega very rich if you had one of those. But for me, you see, if there was an urgent phone, use the landline. How did we manage in 1984? We managed quite well, and that's why it's reasonable to say to somebody, you know what? Don't use your mobile phone in work. Or you can use it, but use it in your breaks, use it in your lunch hour. Because the mobile phone is a video recording device. It also takes pictures, and actually we can watch films on it, can't we? So maybe the attention isn't there. So what other policies? Maternity policies. That changes April to October. I don't want you to copy what the government's got. I don't want you to go onto the internet and write down the policies that are there, because I'm telling you now, they're written for the employee. So you're printing off a policy that's written for the employee. I think you're getting the picture now. The handbook that I'm talking about is written to protect the employer, the manager, the HR person, to protect that person. So we take the law, we twist it, and we protect them. So we're not going to put a massive maternity policy in there. What we're going to do is we're going to look at the problems that employers have. And that's when somebody doesn't say when they're pregnant. When they don't tell you when they're pregnant, they don't tell you that they might be having a baby, and you need to know this because, well, that's the same thing as pregnant and having a baby. But, they don't tell you, and there's a real risk issue here, because what they could be doing is they could be doing a job that might affect them and their unborn child. By having a maternity policy in place that's just telling you how much they're going to get paid is not protecting your business. By having a statement in place that says you have to tell me when you are pregnant, written at the earliest stage possible, is protecting your business. So a twist on maternity there, a holiday policy that says I have the right to make you take holidays if my business is quiet, a written agreement, but I've got to give you double the amount of notice. So I can actually say if we've got a contract that's cancelled and people have got surplus holidays, if I give them double the amount of notice, I can actually make them take holidays. And also with the holiday policy, we've got to manage it. Remember that. If you're left with people, they've got holidays at the end of the year, then we've got a problem here. We might be affecting the working time directive here. You need to manage it. And if you I can't go into details on holidays at the moment, but we're going to do a webinar again, a full-blown webinar on holidays, the implications on the working time directive, how many holidays that people can have, but also if you've got to remember this, the statutory minimum, if somebody is not taking their statutory minimum in 1 year, then, and they're carrying the statutory minimum over, that's against the law. Anything above the statutory minimum, they can carry over. So remember that. Sickness policy, stress policies to protect you. A wastage policy, amazing policy to save money. So a wastage policy that says to somebody, if you lose the shutter keys again, or you damage my vehicle again, or you break something in work, and remember we take each case on merit, or you make my business lose money or cost my business money, if I'm ever at a loss because of you, I have the right to take that money from you out of your wages. And you just watch how many people don't damage your car. Watch how many people don't lose the shutter keys, and how many people bother to turn off lighting and heating as well. So wastage policy is something that I recommend in any business, and it's also preventative if you've got a malicious employee that might deliberately shove some socks down the drains in work and turn the taps on overnight and flood your business. You find out it's that person, you can actually bill them for all that, okay? So wastage policy is amazing. A training policy. I pay for your training, and if you leave within a year, you owe me that money back, end of. If you leave within 2 years, 18 months, 50%, after 2 years, we'll write that one off. And then we've done a webinar on this, data and inventions as well. People who create things are working on things at work. So what about a data and inventions policy as well? And it protects you. But also as well, with the data and inventions, I'm doing a webinar on Wednesday actually about covenants and people stealing your data and going to work for competitors, and that again goes into the inventions data and working for other people. So probationary and suitability clause, and I'm going over here, so I hope you're going to be all right for another 5 minutes. But probationary and suitability, please listen to this one here. This is an amazing policy to have in place. That picture of me at the very beginning, I'm your new employee. I spoke the part. I said the right things at the interview and you took me on, but it's become apparent within the first few weeks that you don't really like me. And in fact, your clients don't, and nobody does in work. I'm just not suitable for the job. Have you got a probationary period for a start in your handbook? And in the handbook, do you also say that you join me in an initial probationary period of 3 months. During this time, your work performance and general suitability is assessed. If it's up to the required standard, that's great. Your employment will continue. But if it's not, we have the right to extend your probationary period up to another 3 months, so 6 months maximum. But during that probationary period, we do have a suitability clause. And what it says, if you are not suitable for whatever reason, I don't have to give you a reason, but you're just not suitable, I have the right written in my handbook that says I can just say to you, please leave, without any comeback. Do you have that suitability clause in your probationary period? Amazing procedure and policy. And then there's lots of policies and procedures you can have, but they've got to be tailor-made for you. They're assorted and they're business appropriate. What might be okay in one industry might be totally different in another. So using a mobile phone in, for example, the MOD will be gross misconduct. But using a mobile phone in an office environment might not be. So you've got to remember that with your policies and your procedures. So, we've got lots of policies and procedures there that we've gone through. We've gone through lots of top tips here. But the big ones that stick at the moment are the ones that are associated with the Working Time Directive. So that's holidays, break policies. And, one of the oldest tribunals I can remember and think about, and this is years ago, actually the payout then was 11.5 grand. So that just shows you how long ago it was. And it was, it was a care home where people took their break. They all went at the same time, and it just so happened a care home owner actually turned up to work when she was going out on a social event, and none of her staff were on the premises. She was amazed. She waited, we know, 1.5 hours for their staff to return. When they returned, she said to her staff, you know, she literally was so angry she sacked them all on the spot. I won't tell you what she said because she sacked them all on the spot. And then what happened is she was so angry that when she was so angry that she ended up in a tribunal, so her anger had taken over here. But what you see, why they won at tribunal, and they won the maximum award, which was 11.5 grand each, was because nowhere did it say that when you take your breaks, you can't take them together. Nowhere did it say that when you take your breaks, that you have to take it staggered. They all took their breaks together, and it didn't say they couldn't leave the premises either. So again, the policies that stick out to me at the moment are the working time directive ones. That's breaks, that's holidays, and that's working for other people. And having a term and condition in there that says, if you want to work elsewhere, you need to apply in writing to me first before you do it. So these are just some of the policies that I would recommend. So I'm going to give me 2 more minutes now, and then we're finished with this webinar today. And I would just want to say the foundations of a disciplinary process should be in line with the ACAS Code of Practice. Ensure the disciplinary policy and procedures include examples of misconduct. Examples of misconduct are, you know, things like failure to abide by the general health and safety rules and procedures, smoking in designated non-smoking areas, rudeness, persistent absenteeism, lateness, unsatisfactory standards of work or output of work, failure to adhere to stated policies and procedures. That's just some of the reasons, and that would be different for each business really. But the foundations again of the ACAS Code of Practice is make sure employees are aware of their if instigating disciplinary procedures, and ensure the detailed process in the disciplinary procedures does not hinder you from following the stated process. Make it simple. Don't jump in, by the way, during the investigation. Have your facts in place. Here at this stage, so you can do investigations and then invite to a disciplinary hearing in writing with reasonable amount of notice. And don't just write the letter and throw it away. You must keep a copy of it. The invite letter should include the following: the details of the alleged misconduct and any evidence to be used at the disciplinary hearing as well. You must have the date and time of the disciplinary hearing on the letter. You must put in there they have the right to be accompanied by a companion. I would say fellow employee or trade union official, not really a companion. But remember, age appropriate. If you've got workers that are 16 or 17, they might feel better with their parents. They could have a companion, but make sure that, you know, you don't do that for somebody that's been there for years or somebody that's older, because you might find their partner coming in or their friend who's a 22-stone doorman, you know, who's angry about the way you've treated their friend, and you want control at these hearings. So hold the hearing, and that's going to be covered in the next part. So when you do have a hearing for a disciplinary, approach the hearing bearing in mind that you don't want an employment tribunal. This is why we have policies and procedures in place in the first place, because they're preventative, and we're trying to avoid this tribunal. You are the chair. It's about the control. So let the employee present their response to the alleged matters of concern. Have a note taker present in the disciplinary hearing, because it's very difficult to take notes and listen at the same time. Both parties should ultimately agree the notes of the disciplinary hearing, and that was with a signature on it as well. And the focus of the disciplinary hearing should be on the matter of concern. So don't go off on tangents, you know, deal with them separately. Be aware of tactics. Employees may attempt to divert it and deflect the hearing away from the reason, but remember, you're in control. So the decision or the outcome, don't appear to make it or advise in the disciplinary hearing. Remember what I said about that letter? They even typed up the outcome of the disciplinary when they invited them to the disciplinary, if you get me here, you know, and they sent out the outcome before they'd even sent out the invite. So people do sometimes make a decision before they even go into an investigation. Don't do that. And this will appear that you make no consideration or reflection on what's taken place. And, you know, and the employee will pick up on that. Advise of the outcome or the decision in person or in writing. Issue the appropriate level of warning or dismissal. Remember, as I said, what might be gross misconduct in one industry might not be in another. Provide the right of appeal against any level of warning and dismissal. You need to put that in the letter. And normally and ideally, a different individual, where possible, should hold each stage of a disciplinary situation, the investigation, disciplinary hearing, and the appeal. And that stands you in good stead, you know, if you did have a tribunal. So 10 top hints and tips for sacking an employee with not ending up in a tribunal. Have a disciplinary procedure in place. Make sure employees are aware of the procedures and misconduct. Don't assume. Let the facts speak for themselves. Aim to be fair, consistent and reasonable in the application of the disciplinary procedures. Follow your processes, use balanced and neutral language. That's not just in that process, but also in your policies and procedures as well. Don't prejudge or preconsider, and consider the bigger picture. I hope today you have enjoyed my webinar. Previous webinars that I've done are available on YouTube. This one will be loaded later on today, so try and access it later on today. You can actually get it with the recording as well. So if I've gone very fast through this webinar today, I know the attention span, maximum 60 minutes I have. So if you want to listen to me again and take notes, I'm going to be on YouTube under Peninsula Business Services. That's PBS/YouTube. You'll find us under Peninsula Business Services. If you want to contact me about anything I've said today, or you'd like some free advice off me, contact me. It comes direct to me, Amanda Chadwick. So contact me at free@peninsula-uk.com. That's if you want some free advice. If you have listened to me today and you think, do you know what, I wouldn't mind Amanda presenting a webinar for my clients. So if you're linked with an association, a federation, you have a business letter that goes out, or you have a business group of people that get together and you'd like a speaker, I do actually visit people face to face. I don't just do webinars. And if you'd like an event hosting, contact me at amanda@peninsula-uk.com. That's no cost to you whatsoever. I can come and do an event for you talking about any subject that we covered today, or any particular piece of legislation for your business clients, and it might be very useful to you. I hope you've enjoyed today's webinar. Feel free to connect to any of the webinars I do in the future. I know Wednesdays is on, as I said, protecting your data, stopping your staff going to a competitor. It might be something you're interested in, and I hope to speak to you again soon. So thank you very much for listening to me. It's Amanda Chadwick signing off at Peninsula Business Services. Thank you very much. Bye-bye.